I think we're going to pick up where we left off. Judge Harner, or actually Professor Jacoby, historically, when the private sector was doing college loans, the laws were in place to give them a assurance that they would not easily find themselves with no money as a result of bankruptcy, and that allowed for a given level of return on investment, but most importantly, a return of capital over time. We took it away from them, we put it in the government's hands. Since that time, the government has taken massive $100 billion plus losses. As we're looking at a change that liberalizes, under the Biden administration, liberalizes dramatically the ability not to pay it, how do we reconcile the fact that there was a mandate from Congress that it break even? Do we increase the interest rate, or do we continue subsidizing people who get a college education and then don't want to pay for it?
I'd first observe that the existence of protection in bankruptcy is not what causes someone to pay or not pay. I think we're finding that many people are unable to pay either way.
Well, but let me challenge that. Mm-hmm. The balance of undue and the ability to discharge, there's no question at all in any bankruptcy, the judge, any judge, has the ability to set up a schedule if you have the ability to pay, or a deferral until you do. So I'm going to challenge that and say, even if you can't discharge it now, you don't have to pay it now if you're unable to. Ultimately, the question is, should you eventually pay it? And we have had members of Congress making $174,000, by the way, who have never paid back their college loans. Is that fair?
With respect, Congressman,
skip the respect. I'm a congressman. I can take it.
Great. Still with respect, I need to tweak the premise because judges almost never see the underlying details of these cases. There's a complicated procedure in addition to all of the disclosures for a financially distressed family makes in bankruptcy. They have to do a separate process for it ever to get before a judge. A judge does not have the opportunity under the law of this land to do what you're saying.
Congress has a balancing act. Do we turn this back over to the private sector and allow them to dramatically increase the cost of student loans so that it pays for itself based on the events on the ground? Or do we continue simply writing multi-billion-dollar per year, $100 billion and more per year, taxpayer money to pay for people's education? Are we effectively turning the loan program into a Pell Grant? And the answer, of course, is if we don't make a change, we are. So is there anybody that disputes the fact that Congress does not want this to be a subsidized program, but it has become a subsidized program? So back to the bankruptcy, if Congress's intent was that you not be able to bankrupt out from underneath it, is the current balance in this undue harm, is it in fact out of whack based on the fundamental, Professor Baird, you look like you want to answer, the fundamental question, which was Congress said, this isn't something you bankrupt out from underneath because it's too important, and and we're not talking about people who had strokes the day they graduated from college. We're talking about people who didn't get a job or who have decided to do something that doesn't pay enough, and so they use the bankruptcy court to discharge and then at a later time make the money from their education often. Professor?
Oh, I think it's important to distinguish between the student loan problem, which is enormous, and the bankruptcy problem and the particular types of people who enter into bankruptcy. I think, unfortunately, many of the debtors we're talking about in bankruptcy, the money is uncollectible in the sense that interest actually builds up faster than they're able to pay it off, given these numbers. It's a difficult problem.
Let me close with one quick question. The IRS does not allow discharge in bankruptcy effectively, right? Therefore, why is it that if we consider this similar, we can't have a abatement and other process as we do in the IRS, but ultimately have the principal remain until discharged or agreed in some program? Anyone have an answer on that, Judge or Professor?
I'd like to answer that. There was a time when an individual who completed a payment plan through a Chapter 13, at the end of that, would have some relief at the end. Congress eliminated that, and I don't think they gave that as much deliberation as you might today. So there is room for looking historically at the different levers and different pieces one can adjust in this system to move more in that direction. What we have now doesn't do any of those things that you're talking about.
To be continued. Thank you, Chairman.
Gentleman's time